Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving rights and liabilities of shareholder, a key topic in business law under FLK1. Let's dive in. A shareholder holds 8% of the issued share capital in a private company which is proposing to allot new shares. The company has unamended model articles and only one class of ordinary shares. The shareholder has received notice that the company plans to issue new shares to external investors and does not intend to offer him any of the new shares. He is concerned that this would significantly dilute his holding and seeks advice on what rights and remedies are available to him. Which of the following best describes the protection available to the shareholder? A. The shareholder has no protection as he does not hold a majority. B. The shareholder has a right to apply for shares under the company's articles. C. The shareholder can block the allotment using his voting rights. D. The shareholder is protected by statutory preemption rights. E. The shareholder can insist that the allotment be approved unanimously. The best answer is D. The shareholder is protected by statutory preemption rights. Under Section 561 of the Companies Act 2006, shareholders in a private company with unamended model articles and one class of ordinary shares have statutory preemption rights. These rights require that any new shares must first be offered to existing shareholders pro rata to their current holdings before being offered to outsiders. This is to protect shareholders from involuntary dilution of their ownership. The offer must be made on the same or more favorable terms and must remain open for at least 14 days. These rights can only be disapplied or removed by a special resolution, 75% majority, of the shareholders or by amending the articles, neither of which has occurred here. Since the company has unamended model articles and only one class of ordinary shares, a shareholder is protected by statutory preemption rights. Scenario 2. A shareholder holds 40% of the issued share capital in a private company that is proposing to undergo a member's voluntary winding up. The company has unamended model articles and only one class of ordinary shares. The shareholder disagrees with the decision and wants to know whether he can take any action to stop the winding up. Which of the following best describes his position? A. He can block the winding up by voting against the special resolution. B. He can block the directors from making a declaration of solvency. C. He must accept the winding up if the board decides to proceed. D. He can only challenge the winding up by applying to court for an injunction. E. He cannot stop the winding up because he is not a majority shareholder. The best answer is A. He can block the winding up by voting against the special resolution. Members' voluntary winding up requires the passing of a special resolution, Section 84 of the Companies Act 2006, which means at least 75% of shareholders' votes, by value of shares held, must be cast in favor. The shareholder in question holds 40% of the issued share capital. This means he can prevent the special resolution from being passed, because the maximum in favor would be 60%, which is less than the required 75%. Therefore, by voting against the special resolution, he can block the winding up. Scenario 3. A shareholder holds 40% of the issued share capital in a private company that is now proposing to be wound up due to significant debt. The company has unamended model articles and only one class of ordinary shares. The shareholder is concerned about his potential liability and wants to know whether he could be held personally responsible for the company's debts. Which of the following best describes his position under English company law? A. He is liable for 40% of the company's debts because he holds 40% of the shares. B. He is not liable for any debt under the principle of separate legal personality. C. He is liable up to the amount unpaid on his shares, if any. D. He is fully liable for all debts if the company becomes insolvent. E. He is liable for 40% of the company's debts only if he signed a personal guarantee. The best answer is C. He is liable up to the amount unpaid on his shares, if any. Separate legal personality. A company is a separate legal entity distinct from its shareholders. This means the company itself is liable for its debts, not the shareholders personally. Limited liability. Shareholders' liability is generally limited to the amount unpaid on their shares. If shares are fully paid, shareholders usually have no further liability. Personal guarantees. Shareholders may also become personally liable if they have given personal guarantees or otherwise agreed to be personally liable. No proportionate liability based on shareholding. Holding 40% of shares does not mean the shareholder is liable for 40% of the company's debts. This table outlines the legal principles we walked through. In Scenario 1, a shareholder in a private company is protected from dilution under Section 561 of the Companies Act 2006, which gives existing shareholders the right to be offered new shares before they are sold to outsiders. This right applies unless it has been removed by a special resolution or change to the articles. In Scenario 2, a member's voluntary winding up requires approval by at least 75% of shareholders. A shareholder holding 40% can block this by voting against it. In Scenario 3, shareholders are generally not personally liable for company debts because the company is a separate legal person. Their liability is limited to any unpaid amount on their shares, unless they have personally guaranteed the company's debts. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.